SJC-10476, Commonwealth versus Nat Fung Ing.
Okay, Attorney Sultan. Morning.
Good morning, Madam Chief Justice, and may it please the court. This is the third time this court has heard oral argument in this case, and I welcome the opportunity to seek to persuade the court to remedy Yat Ing's unjust conviction for first-degree murder. Now, in many first-degree murder cases, defendants make arguments for relief under 33E in a rather perfunctory fashion. But based on the totality of the record in this case, including the circumstances of the offense, the defendant's personal characteristics, and the poor quality of legal representation he received at trial, this case, I submit, makes out a compelling case for relief under that statute, and I would like to start there, if I may.
Can I ask a question, Mr. Sultan, on the 33E part of it? Because I understand your argument, and it's well taken, given the what we've said about the defense of self-defense in the trial lawyer's decision to pursue that path. That goes in the mix. When we look at this case, and we have some of the other cases we granted 33E relief on, where we talk about hotheads and fights and the like, have we gone so far when someone retrieves a weapon? That's my only question I have for you.
Your Honor, I guess what I would say about that is, look, obviously, every case, as the court has said many times, every case is different, and it has to go to, it's not just the circumstances of the offense. One of the things about 33E that this court has said, and why this is such a special kind of consideration, given in no other kind of case, is because the punishment is so draconian, is so final, that the court looks at everything, looks at the totality of the record, including things that the jury may not even have seen, in order to determine whether a reduction is more consonant with justice. So to answer your question, no. I mean, looking at the most, I've only looked at the most recent cases where this court has reduced verdicts. And it's been done with increasing frequency, frankly, by this court. So in the last 10 years, you've got cases like Concepcion, you've got Vargas, you've got Dowds, you've got Nemec.
Yeah, one of them, the hothead fight category.
None of them involved a fight where somebody retrieved a weapon. No.
No, but they're all in that hothead fight type category.
No, they're all different. I mean, they're all different. I can't say this case is just like some other case.
Dowds had a mental health issue.
And a number of these cases did. I'm not trying to claim that this case is like some other case. This case is sui generis, I submit. So, I understand for purpose, this court has obviously held that the circumstances here did not justify voluntary manslaughter upon reasonable provocation instruction. I get that. I'm not here to re-argue that. But what I'm saying is 33E allows this court to look at everything, and that's what I'm going to ask the court to do.
But I guess the larger point you're making, not to rephrase what you're trying to argue, but is that we should, in our calculus, put in the ineffective assistance, even if we don't find it was ineffective assistance.
That's part of it, Your Honor, but let me start with the circumstances. And I guess before I do that, here are some of the factors that this court outlined in Colleran, where a case where it reduced a verdict back, I think, in 2008. So it said these were some of the questions the court should ask under 33E. Whether the homicide occurred in the course of a senseless brawl, whether a minor controversy exploded into the killing of a human being, whether the entire sequence reflects spontaneity rather than premeditation, whether the defendant and the victim were strangers, whether alcohol and drugs were involved. And then it goes on to about the personal characteristics. So those are some of the questions that the court should ask in deciding, look, should this guy really spend the rest of his life in prison? Let's look at this broadly.
Yeah.
That is...
I hear you on the broadly, and I'd like you to, before you run out, we have plenty of time yet at the moment, before you run out of time, to talk about the defendant's personal characteristics that we would factor in. But can you also, you mentioned some of these factors, can you address the lack of premeditation or the time element? Because the issue I see with the argument in the 33, in that part of it, is that there is a moment where it's, first of all, it's not his fight. Second, he goes to his car, retrieves a weapon, and goes back. And that actually takes it out of a lot of other kinds of cases, because there are a few moments where obviously he can just get in the car and drive away or choose not to pick up the gun.
This court, I think Your Honor put it very well in the prior decision. Because he reached for a gun, not for his keys, there's no self-defense. I understand. So in terms of timing, and it's different than for example, a case that the court cited, Coleman. He did not retrieve a gun and come back. That's not what happened. What happened was, and let me just go through the circumstances. So Mr. Ng, a young man, 24, recently honorably discharged from the military, going to college, working as a security guard at Harvard, witnesses this altercation outside this club in Boston. He witnesses it. He's not part of it. He witnesses it. And he sees a large, violent man assaulting several individuals, including a woman who he pushes to the ground. Mr. Ng intercedes. He intercedes, and then the violent man threatens him and pursues him as Ng goes back to his car. Ng reaches his car. He retrieves a gun. He's still at his car. He doesn't come back somewhere. He's at his car. These individuals are 10 to 20 feet from each other, depending on, you've got a bunch of different witnesses. Two of them said that the decedent continued to approach Ng. One of them, that the Commonwealth wants to talk about a lot, said that Ng was coming back towards the decedent. A number of others said they were both stationary. And Ng fires. Then Ng is goaded by this individual at that point. You know, come on, shoot me. What are you going to do? And then Ng fires one shot and kills him. This all happened very quickly. I can't say it happened within 1 minute or 2 minutes, but it happened very quickly. There was no time lag. There was no going to his house a mile away and getting a gun and coming back to a scene. This was a set of circumstances that in the real world is reflective of, much more suggestive of an emotional, angry, spontaneous response than it is to some kind of premeditated plan. There is no evidence that Mr. Ng went to that club that night looking for trouble, let alone expecting to shoot somebody. To say that he was in a wrong place at the wrong time, sounds glib, and it's not to excuse his conduct at all, his criminal conduct at all. But in fact, that's kind of what happened here. I mean, looking at it from a real-world perspective, there's no reason to think anything else. These people didn't know each other. They had no prior interaction. I mean, this case does not resonate as a first-degree murder case. That's really why I'm making this argument. And so, yes, I asked the court to look at the circumstances in that sense, in the Colleran sense, looking at these kinds of questions, not in the legal sense. Yes, there was more than sufficient evidence to convict of first-degree murder. Yes, I understand the court has said he wasn't entitled. The court said, in fact, as a matter of law, the defendant was not entitled to an instruction on any absolute defense or mitigating circumstance of the charge of murder in the first degree, based on these facts. I understand all of that, but that's what 33 is for, and that's why I'm asking.
So the point on premeditation, I guess, is that all of the hothead cases, so to speak, Colleran cases, have sufficient evidence of premeditation, or else we would have said there was not enough evidence for first degree. So that's a given.
Yes,
now we have to look.
Yes, Your Honor. It is a given. But sometimes, there are cases where defendants argue there was insufficient evidence, but even if there was 33, I'm not arguing that. There's no sufficiency of the evidence argument here. He committed a crime. There's no question about that. This was an unlawful shooting. Okay, and based on this court's prior decision, this was a murder, okay? There's no other way to read the court's prior decision. But first-degree murder or second-degree murder, there's a big difference. One, this man is going to die in prison. The other, at least he has an opportunity to face the parole board and seek parole. That's really what I'm here about today, and that's why I asked the court to. That's why I'm starting with this particular
Our standards
issue.
Pretty open-ended, but do you have refinements for it? Because you're sort of asking us to pick and choose in these cases. And to be honest, our standards aren't that clear about when we're going to lower the verdict. how would you improve those standards and apply it to your client?
Your Honor, I don't think there's any, I think that the standard is exactly what it should be, which is that the court, for any reason, that's the court has said, any reason that's consonant can reduce based on the entirety of the record, including what the jury saw and what the jury didn't see, the court can make a determination. It's an equitable determination so I don't think there should be objective criteria any more precise than what the court has laid out, such as some of these questions in Colleran. Generally look at the circumstances of the offense, look at the defendant's personal characteristics, and then look at the trial. And those are kind of broadly the things that I'm asking the court to look at. I don't think you can pigeonhole it anymore. I don't think you can say, I don't think it's a place for making nice legal distinctions. This really isn't, everything this court does is a matter of law, but this really isn't a legal determination. It's an equitable determination. That's really what it is. And I don't think, and it's not about trying to create some precedent.
Could I shift you to your, unless my colleagues have more questions on
Well, I
this?
do have one
Okay,
other
sorry.
question about this. You've mentioned twice now that we should include in our equitable determination what the jury did not see.
The court has said that.
What are you referring to in this case?
Well, I'm referring to as Mr. Ring didn't testify. So number one, his personal characteristics, which were presented, which they were in the record because they were part of his Rule 25 motion post-trial, letters from his family, information about his personal history. There was information in the record in the bail motion after his second motion for new trial was granted. So in this case, it includes the fact that he's a person of high character, that he was honorably discharged from the military, that he was a hard worker, that he had no prior record of criminal convictions, no history of violence. Those are the kinds of things the court can and should consider in deciding whether or not a first-degree murder conviction should stand. It's wonderful that the legislature has given this court that authority, and I'm very happy to see the court utilizing it much more over the last decade than it did in, say, the prior decade, because that's really what this is, a court of last resort, and this is kind of the end of the road for these defendants. If this court does not grant Mr. Ng relief, he'll die in prison. So yes, look at his personal characteristics. Also in this case is an affidavit that Mr. Ng submitted in support of his first motion for new trial, which is before the court, which actually sets forth his state of mind at the time of the killing. That he was drunk, that he was angry, that he was upset, that he was scared. I don't have it verbatim, but it's in the record. So the court can consider that as well. That certainly was nothing the jury they didn't hear it because he didn't testify. So that's part of looking at the record as a whole, his personal characteristics. And the third thing is the trial. And the court, I understand whether or not this court holds that he received constitutionally ineffective assistance of counsel. Nevertheless, his lawyer made a dramatic promise in her opening statement that she didn't keep, that this court
Before we
previously
go back
said.
to that one, because you've raised a new issue that interests me that I'd like you to address, which is the critical stage. So he's excluded from every sidebar except for during jury selection. Do you want to address that and provide some?
I very much do want to address that, Your Honor.
Okay.
Your Honor, I think it's a very important issue. So he's excluded from every substantive sidebar during the trial over objection. And, you know, this court has...
Can I ask, Mr. Rankin, probably no one has argued more cases than you have.
I'm sorry, Your Honor?
Probably no one has argued more cases than you have. How many times were you excluded from all sidebars?
Well, how many has my clients been excluded?
Yeah, excuse me.
I'm never excluded, right? They always let me come. I'm sure other people have tried more murder cases than I have, but in general, in recent years, most trial judges have allowed my client to be at sidebar, but it's not ubiquitous. So it's still, and it's remained something that, I was shocked going back to reading all of the case law on this subject, that this court really hasn't ever pin down.
It's similar to The View.
Well, we can go back to Snyder, which is 1934, where the Supreme Court said 5-4, upheld this court in saying the defendant does not have to be on a view. So I submit that a view is sui generis. Let's look at more modern law. Okay, over the last couple of years, this court has very eloquently and repeatedly said, in cases like Cologne and Francis, has emphasized the importance of the defendant being physically present to see and hear and understand what's going on.
Francis, which I'm familiar with, you know, he's excluded from the selection of counsel, which it's very different, right? He clearly should have been present when they pick a lawyer.
None of these cases involve sidebars, okay? But, I mean, frankly, look, what is special about a sidebar? The sidebar is part of the trial. And it's a part of the trial that's very important, as it was in this case, where substantive issues about whether or not a witness is going to be permitted to testify or the scope of that testimony is addressed. I mean, it's all well and good to say the defendant has a right to be present when the witness testifies, but the defendant does not have a right to be present when the judge decides whether the witness will be allowed to testify.
It's not one size fits all, because of course the sidebar, when the judge calls up and say, hey, everybody good with taking lunch.
And I say that in my brief, Your Honor.
It's the substantive ones.
And this court said way back in Angiulo, 40 years ago, that if it's purely administrative matters, the defendant doesn't have to be there. No question. But anything substantive. Here, they're discussing whether or not Sierra is going to be allowed to testify. They're discussing the scope of the testimony about Ng's military records. The judge is making comments about the weakness of his evidence, about his subjective state of mind, which he says in an affidavit, I would have testified if I had heard the judge say that. The idea that, well, we're going to draw this nice distinction and say the defendant has to be present at these proceedings that are part of trial, but not this one, it doesn't make any sense.
And you certainly look, there are no cases that I saw in the brief where anybody's actually really discussed sidebar, as far as either a Sixth Amendment or a due process issue, right?
I've seen no case from this court talking about specifically about sidebars. But
or elsewhere.
Well, there are some federal cases that the government
cases
cited, and I tried to address those. Most of those, there was no objection made. But look, this court has its own prerogatives under Article 12. The court has said it's very important that the defendant be present so he can participate, so he can see, hear, and understand what's going on. Judge Cipher wrote in an appeals court case in Campbell that the defendant has, as a participant in the events being discussed, has a unique perspective. Well, he does have a unique perspective, but more than that, he has a right to be there. His life is on the line. And to say, well, we're just talking about legal stuff, so he doesn't need to be there. No, this is a substantive, critical part of the trial. And he has a right to be there, and this court should proclaim that he has a right to be there.
Are there any federal, I mean, they cite federal cases going their way. Are there any federal cases on sidebars going your way?
I haven't researched federal law to that extent. I would suspect there are not. I would suspect that the federal courts have decided to parse this right more, as in many other areas, constitutional areas, more narrowly than this court can and should.
Do you think it's without limitation where a judge could make a finding that perhaps the defendant's being unruly or whatever?
Absolutely. As I say in the brief, of course the defendant can forfeit his right to be present. No question, based on misbehavior, and he can waive it by not asking to be there. I'm not saying he should be there in every case.
And all routine security concerns would be wrapped into the decision, too.
Of course, Your Honor. Right. But as with the court closure, if the defendant is going to be excluded, then the judge needs to put on the record the reasons why.
In this case, it's different because there was a request to be present.
There was a specific request, and the court let him be so he's allowed to be present at sidebar when the jurors are being questioned, but no, during the trial, we're not going to let him. What is I mean, there is no logical reason for that distinction.
There is, because the immediate input of the defendant during jury selection is different than, right? So if you obviously picking juries and you say, what about number 12, et cetera? The other reason is you'd have to go from the sidebar to the table, ask the defendant what she believes and come back, right?
Yes, Your Honor, you're right. I mean, the
That's
jury
unique
selection.
about jury selection.
Yes, jury selection is different, but that's not a basis for a distinction. I mean, this is a fundamental right to be present at your trial, not just part of your trial.
So if you're right and it was error, is it prejudicial error? Is it structural error? What is the
Well,
standard?
that's a great question, Your Honor. I submit, number one, it is structural error, but this court has said in cases like Owens and Sleeper that it's not automatic reversal, that you do have to look at prejudice. Now, in this case, it's kind of sui generis because he filed an affidavit saying, I would have testified had I been there. Now, the motion judge was not required to credit that affidavit, but the motion judge denied his request to present evidence in order to make a more robust showing of prejudice on this. And he can't be faulted for the fact that the motion judge refused his request to hear evidence. So I would submit that if prejudice has to be found, and if his affidavit is insufficient, then I guess the court would have to remand for an evidentiary hearing on that narrow issue of prejudice. But I think this court should say it's an error.
One fast question, and that is that you say he refused the request for evidence. Does the record contain a proffer of the evidence, or is there anywhere we can look for that evidence?
Well, no, Your Honor. There was an email that was sent from the court clerk to counsel saying the judge is not going to. The motion requested an evidentiary hearing on two issues: courtroom closure and this sidebar exclusion. There was an email. It's in the record, I think, at page 60 of the appendix, saying the court will hear evidence on the courtroom closure, but only argument on all the other issues. So no, there was no. It's a fair question, Your Honor. There was no offer of proof made below. But I think that the denial of an opportunity for a hearing, I don't think this court has generally required an offer of proof in deciding whether or not a motion judge abused his or her discretion in denying an evidentiary hearing on a motion for new trial. I thank the court.
Thank you.
Thank you very much. Okay, Attorney McLean. Which argument do you want to start with? He's made quite a few good arguments.
Good morning, Your Honor. May it please the court. Ian McLean on behalf of the Commonwealth. Unless you'd like me to start somewhere, I'll start with the 33E argument. Justice Gaziano, I would agree with you that this case is different from the simple hothead cases. And
I think if you look at Colleran, it doesn't say you have to satisfy all these 5 things. It says these are the factors. So if you satisfy 3 of them, right? I mean, and that's the nature of 33E. It's frankly a judgment call by us.
Certainly, Your Honor, but I think you went directly to the most important factor here. That was the 5th factor listed in Colleran, whether the defendant carried a weapon to the scene or left and returned with the weapon. That distinguishes this from the sort of hothead cases where there's an argument and somebody draws a knife from their pocket and stabs someone and they die. Totally different situation here. And there are a few facts that were left out in the discussion here that lead up to him leaving and getting a weapon and returning to the scene. The first is he interjected himself into a scuffle that was basically done, that he was not a part of. He was told it was over. And he said, I have business. Then he interjected himself, initiated an argument with the defendant, during which, what's up, tough guys? You think you're bulletproof? I got something for you in my trunk. And then he went to his car and got a gun and re-engaged the defendant, who this court found in its prior opinion was at this point backing up when the defendant raised the gun and shot him one time in the forehead. Backing up 15 to 20 feet away. That's categorically different from the hothead cases. So there was no miscarriage of justice here. This was just an unambiguous case of first-degree murder.
Where do we put in the ineffective assistance of counsel? Say we agree with you that it wasn't reversible on the ineffective assistance of counsel, but we have a problem that the defense counsel did not argue for second degree. Does that factor into our analysis on 33E?
Well, the entire record factors into the analysis, right. Your Honor. So yes,
how do we take that into account?
Your Honor, I don't believe there was ineffective assistance of counsel in trial counsel not shifting her strategy during trial and arguing for guilt.
She argued a theory that was legally doomed to fail.
However, it was put in front of the jury, Your Honor. It made it to the jury. That's not ineffective assistance, that's incredibly effective assistance. She managed to convince the judge that there was evidence that the defendant retreated such that it could go to the jury. But that also wasn't the only defense that she put forward here. There were two other defenses she put forward. She actually attacked the malice in a second-degree murder charge, and you could find that at the third page of her closing argument. And then I would point the court to what I would call a pretty strong attempt at a Bowden defense, basically.
But what does Bowden do in this analysis, as far as a second degree?
Well, Your Honor, I think your point was that she was ineffective in her assistance, that she left the defendant without a defense. I disagree with that and say...
She never challenges premeditation, correct?
No, she did not really challenge the premeditation, but she challenged the adequacy of the investigation again. So the three defenses she went with: self-defense, going after malice for murder 2, and then attacking Bowden, which is basically just a way to try to muddy the waters and get reasonable doubt. All three of those are complete defenses. She wasn't looking for mitigation. It's pretty clear they weren't trying to walk out of here with a conviction on a lesser charge. She said she didn't even want the reasonable provocation instruction. They were going with an all-or-nothing defense, which can be a viable defense theory. Just because it didn't work out in hindsight doesn't mean it was ineffective at the time. So I would then turn to the discussion about sidebars. Yes, Your Honor, there was an objection here, but it was a blanket objection at the beginning of the trial.
Well, but
So every sidebar, the defense attorney has to object?
You got to let the trial judge know why this is a critical stage versus every other sidebar. As you referenced a sidebar where you're talking about scheduling or logistics.
doesn't she object twice? I thought there are two different times where she tries to get her client to sidebar, or at least she brings up the issue, right?
Yes, Your Honor. The initial time, and then the second time is at volume 3, page 122. And what happened in that conversation was a discussion about sequestration of a detective, and then also the use of a demonstrative aid in the form of a step cam.
That doesn't preserve the error in your view?
It would for that particular
The one sidebar?
that sidebar.
Judge Spurlock go further. He says, look, the only time I'm allowing this was for jury selection, right? He goes beyond and explains what his ruling is, doesn't he?
Yes, he did. When she initially said, I expect my client to come up at every sidebar, he said, no, that was just for impanelment. So even if you wanted to consider that the objection is preserved across the entire trial, the Commonwealth still prevails because the right to being present only attaches when it's a critical stage. So we have to look at what constitutes a critical stage. There are sidebars that could be critical stages, and you see those in jury questions, beginning with impanelment, because it's sort of a mixed question of fact and law. You might want to use it for
Counsel, shouldn't everybody, including the prosecutor, the judge, and the defense attorney, be alert to critical stages? A judge shouldn't need a reminder that there may be a critical stage involved, nor should a prosecutor. And I would think a prosecution might want to watch out for this too, and permit and encourage the defendant to be at sidebar.
Well, that could well be, Your Honor, but as this court has found in Robinson, what constitutes a critical stage is left to the discretion of the trial judge.
So if they're having a argument about sufficiency of evidence with the jury in the box, and the defendant's not present, is that a critical stage?
I would say no, Your Honor. So I think about why does the right to presence attach? Think about the bases of it. There's the Sixth Amendment Confrontation Clause issue, so that has to do with the presentation of testimonial evidence, right? So we're not disputing that ever. Even in a motion to suppress context, the defendant has a right to be present. The court's already said that. A purely legal argument would maybe fall under the second way that you find the critical stage, which is the due process right. But the point there, as the Supreme Court said in Kentucky v. Stinser, it doesn't attach when the presence would be useless or the benefit but a shadow.
So a judge could exclude the defendant while they argue the required finding?
It's a purely legal argument. So
Does your answer is yes to that question?
it is a purely legal argument, so I suppose it's possible, but that's not what happened here. The sidebars that we're talking about here were about evidentiary rulings in the trial.
What about
Do you think we'd have a little problem with the federal court if we said that?
You might, but again, those are not the facts of this case or what's presented here. What's presented here are sidebars.
Well, we're trying to test you what a critical stage is when it doesn't involve taking evidence. And it seems to me that some sidebars may be and some sidebars may not be.
Correct, Your Honor. And the jury questions are the great example, not just impanelment, but questions about juror misconduct or extraneous influences on jurors. We've seen those cases before. Potential juror bias, Coulon, Sleeper, Caldwell, Dyer, and all of that makes sense. Those are sort of mixed questions of law and fact.
What about his lawyer puts on that I can't remember the person's name. Ian is going to be Ian's statement that about he's coming at me is going to be at trial.
The Sierra testimony.
Yeah, the Sierra test. And then the judge rules it isn't admissible. And in passing says there's scant evidence of the defendant's intent. Doesn't that gets close, doesn't it? Isn't that, I mean, we're starting to worry at that point whether the defendant has something to add here. By the way, I'm going to ask you also whether that ruling is correct. Doesn't it go to state of mind?
Sure,
Premeditation, but so isn't that a stage where the defendant may have something to add to this discussion?
Respectfully, no. So I think you're talking about two different sidebars there. The first that they're complaining about is the reconsideration on the exclusion of Sierra's testimony. The second being the judge expressing his view about the defendant's subjective fear for self-defense. So I'll start with the first one. The reconsideration argument they're complaining of happened in volume 4 at page 196, and a few facts that lead up to that. The defendant was present for the initial argument about the admissibility of that evidence. That's volume 4 from pages 4 to 13. He was present for the voir dire of that witness, volume 4, 14 to 22. He was present for the argument after the voir dire about that witness, which was volume 4, pages 19 to 20. What he was excluded from was a reconsideration later that day, where the same legal arguments were raised again. The defendant was aware of all of this having happened.
When you say he was excluded, can you just refresh my memory? It's been a little bit. Was he excluded from the sidebar, or was this going on in the courtroom without him?
He was excluded from the sidebar, Your Honor.
Thanks.
And again, that's volume 4 at 196 is where that occurred. And then he was present again for a second reconsideration at volume 7, page 150. So to say that he was unaware of what was going on regarding the admissibility of Sierra's testimony is simply incorrect.
Well, but counsel, don't you think there's a more subtle influence that comes from this, and that is that for the relationship between a defendant and his defense attorney, they need a high degree of trust. And if the defendant can't go to the sidebar when certain legal things are argued and hear the judge say certain things to the defense attorney, it puts more of a burden on a defense attorney than to explain that and to recalibrate that trust because he hasn't heard the direct response.
Sure, Your Honor. And the one time in the record where the defense attorney asked for an opportunity to speak with her client after a sidebar, that was permitted, and she had an opportunity then to consult with her client on the ultimate decision.
Not quite the same.
Sure, Your Honor. But I mean, I'd point the court back to Clark versus Stimson from the Second Circuit in 2000, where they noted that both New York state law and the federal system recognizes a fact-law dichotomy here. And when it's purely a legal question that's being discussed, there is no right to be present, basically because, for two reasons. One, the confrontation clause aspect wouldn't be implicated.
What would you say to trial lawyers that ask you in your office about whether they should encourage or object to the defendant being present? Would you tell trial lawyers in your office, by all means, encourage the judges to have defendants to be present?
Sure, Your Honor. I see no harm from that happening. It's just a logistical barrier. But I mean, every individual trial judge controls their own courtroom, and this court has previously left it to their discretion to determine what was a critical stage or not.
But wouldn't you advise lawyers to say no?
No, I would not, Your Honor.
That the defendant should be there.
I wouldn't go so far as to say the defendant should be there, but I wouldn't advise someone to object just for the sake of objecting. I think the defendant's right to be there stems from two reasons. One, confrontation clause, having to do with testimony being presented, and two, whether they're going to have a substantial impact on what's happening at sidebar. And when it's purely a question of law, the defendant is not going to have a substantial impact. He's just going to be he or she's going to be standing there as a observer of what's happening. So that's the reason the right exists. But even if this court was inclined to extend the right to every sidebar, the defendant would still have to show prejudice here from being excluded. So again, going to him being excluded from that reconsideration about the admissibility of Sierra's testimony, they rehashed the exact same arguments that had been previously made. He wasn't going to provide any additional benefit in that sidebar and get the judge to change their mind.
And in the prior ones that he attended, did the judge make this sort of offhand remark that there isn't enough there? There's something in Mr. Rankin's brief, and I don't have it right at my fingertips, but essentially where the judge says, I see scant evidence of something or other, I can't remember, related to the defendant's intent. And then he keys on that point to say, well, And then the defense said, I would have testified if I knew that. I'm not sure that's supported, but that's in the briefs. What's
Yep.
your response to that?
So that sidebar happened at volume 7, pages 5 through 8. And yes, the judge did basically express an opinion that I don't see much evidence on the defendant's subjective fear here to justify a self-defense instruction. Attorney Scapiccio then argued you can infer it from other evidence, which clearly they then did because the judge determined that the self-defense instruction was warranted. So again, even if you were going to say that was a critical stage, that
But
the-
we say that's wrong in the last opinion, correct?
Correct,
Right.
correct. But even if you were going to say that's a critical stage, there would have been no different outcome here because the judge gave the self-defense instruction. So they got what they were looking for. So it would have been, if it was an error to exclude him, it
Kinda
would have been a
circular.
harmless
He
error.
gives the self-defense instruction he says is incorrect, and because there's not enough evidence, but he doesn't testify, which might have provided more evidence. So it's kind of a.
Yes, Your Honor, it is
chicken and egg.
circular, but ultimately he got the self-defense instruction, and that was before the jury. So the judges,
Which plainly didn't satisfy the jury instruction on retreat.
well, it satisfied the judge's view at the time, and so the
Right,
instruction was
But it
presented.
was, again, doomed to failure, because when you read the jury instruction, it ain't there.
Well, we're then in the realm of a purely speculative argument now of what would have happened otherwise. So again, I would say that that's
Can I
not a
ask-
critical stage.
Can I ask about your research? You've cited some cases. Any cases go the other way?
Not that I found, Your Honor.
Okay.
And I would, again, I'd point you to the Second Circuit in 2000 saying that both New York state law and federal law recognizes that fact-law dichotomy, which would then be consistent with the 6th, the 7th, and the 11th, saying the defendants have no right to be present at sidebar when they're discussing legal issues.
And those cases were Rule 18 or the federal equivalent cases, or are those also constitutional analysis there? Because we can, again, be more protective if we want constitutionally. Were those cases just interpreting the federal rule, or were there also constitutional interpretation? I haven't had a chance to read them yet.
My understanding, Your Honor, is both, the federal rule and the constitutional support as well, which makes sense because the two bases for the right to be present are confrontation clause and the due process right. So if the defendant is not going to have any influence on something where it's a purely legal argument, then there's no due process right for him to necessarily be present. That's basically the reasoning that underpins it
Does he
here.
have to have an influence on something? How do you measure that influence? When you say it's substantial influence, what does that really mean?
The phrase that the Supreme Court used in Kentucky v. Stinson is when presence would be useless or the benefit but a shadow. That's the phrase that they use, which is, I'll grant you, somewhat of an amorphous standard. But if the argument is about the admissibility of a piece of evidence, the defendant's lawyer speaking on his behalf is going to make that argument to the judge. The defendant standing next to the lawyer when he makes that argument isn't going to have any impact.
Did any of the sidebars require the defendant's knowledge of the facts where he could have shared it with counsel to be helpful?
None that come, like, there are 4 specific ones that I gleaned from the defense's brief that they were talking about. I understand they're making a blanket argument for all, but the 4 that I gleaned were the reconsideration argument about the admissibility of Sierra's testimony. No, there was a voir dire, so there was no specialized knowledge there. 2, the admissibility of his military records. Those are just paper documents, so I'm not sure why he would have anything to add to the argument about that it's prejudicial to say somebody served in the Army. 3, the use of a step cane as a demonstrative aid. I don't know what specialized knowledge the defendant would have to contribute there.
Use of, I didn't hear you, a step?
Cane.
Step cane.
Okay.
But he would have knowledge of his military service and what it took to get the marksmanship ribbon, right?
Correct, yes, he would. He would have had knowledge of that.
Can I ask about the admission of Sierra's testimony? So I agree with you on the second, I'm not sure it was ineffective to not argue second-degree murder, but it comes in, his intent is directly relevant, right? And why isn't a state of mind exception that Sierra's testimony is admissible? I missed that. I don't get it.
Well, the state of mind exception, Your Honor, under Woolham, it applies to the victim's state of mind, not the defendant's state of mind. Basically, what he's really trying to do here is exactly what this court talked about in Steves, which is you do an end run around having to testify himself. It's not so really this fits.
Even though they have to prove premeditation, and this relates to his state of mind, that's not an exception of the hearsay?
No, it's not, Your Honor.
Isn't all hearsay exceptions an end run around testimony?
Where
It's an end run when you call a witness when the police officer said the witness said this in an excited utterance. Is that an end run?
Sure, Your Honor, but the reason that those exceptions exist is because there are substantial guarantees of trustworthiness. As this court just discussed recently
Which is
in
what
Steves-
excited utterances do, right? Because excited utterances are before the motivation to call it the testimony.
Well, correct, Your Honor, but here the call was between 20 and 30 minutes after the fact, and the judge decided to exclude it on that basis. And that's not, frankly, the issue that's been raised now. The issue that they're raising now, I say for the first time on appeal, is that this fit within the constitutional exception to the hearsay prohibition. I'd say the preserved issues would have been what Attorney Scapicchio raised, which was state of mind and the residual hearsay expression, which isn't really even a thing.
Well,
But now they're...
it is a thing in Creighton.
So what they're challenging now is that it fit within the constitutional exception to the hearsay requirement. So that started in Silva Santiago, or at least that's the first case I can find where it was recognized, and then sort of modified.
Drayton, not Creighton, right? But we said it was a thing in Drayton.
So then in Drayton, the constitutional exception was expanded a little bit, and there they clarified the test for what qualifies. 2 prongs, critical to the defense and bears persuasive guarantees of trustworthiness. Here they don't satisfy either of those 2 prongs. So regardless of whether you look at it as
But the
preserved
judge doesn't
or
make
not-
a finding about that, does he?
Excuse me, Your Honor?
Did the judge make a finding about the Drayton factors?
No, because Attorney Scapicchio didn't raise that as a basis during trial. She raised residual exception one time and then several times state of mind.
Well,
So-
that is the residual. She can't raise Drayton because Drayton wasn't decided before that, right?
That's fair, Your Honor. Even if you want to construe it as preserved, they
But she
failed
was
to meet-
preserved because she raised residual, the residual clause, and Drayton's a residual clause case. So it is preserved.
All right, even if you want to determine that it's preserved, the Commonwealth still prevails because the 2-prong test under Drayton, they failed to satisfy either. One, it has to be essential to the defense. Here, this would only have gone to one component of the 3 necessary components to get that self-defense instruction. So they would fail based on that. Second, persuasive guarantees of trustworthiness. So if you look back at Steves, which was not that long ago, there, the persuasive guarantees of trustworthiness came from a series of interlocking affidavits, all attesting to the same components, and that was the guarantee of trustworthiness. We don't have any of that here.
So, so a defendant can never put in his own state of mind.
He certainly can by taking the stand and testifying to it. But what they're trying to do here is exactly as this court acknowledged in Steves happens frequently. A defendant makes a somewhat self-serving or exculpatory statement, some hearsay statement somewhere, and then wants to get it into evidence while avoiding cross-examination. That's not the rarest of cases, as the constitutional exception to the hearsay requirement exists to fulfill. That's a fairly common occurrence, as this court recognized in Steves. And I see that I have run out of time, unless anyone had any questions about any of the remaining issues.